Singer, CMO of Oligarch Media, and today we are talking to attorney Mace Yampolsky. Mace has been practicing law for over 30 years and is certified as a criminal specialist. He's also AV rated, and I should mention that only 7% of law firms in the United States have attained this rating. He's even won a case reversing a death sentence in front of the US Supreme Court, which is pretty impressive. Mace often appears as an expert commentator on local and national television, like Court TV, and he handles all types of criminal and personal injury cases. Today's topic is domestic violence. So Mace, welcome. And why don't we start off by defining domestic violence from a legal point of view?
Okay. Hello, Singer and everybody else. Domestic violence is a crime that's essentially the same as battery, except the people that are the quote-unquote victims are a specific class. In other words, if I hit my neighbor in the face, that's battery. If I hit my spouse in the face, that's domestic battery. And the victims that make it domestic violence or domestic battery, we use the terms interchangeably, are a spouse, a relative, a roommate, someone with whom you've conceived a child. Those are the protected classes. So if you commit a battery or you're accused of a battery with one of those people, it's considered domestic battery rather than simple battery. And here's the difference. For misdemeanor battery, you're looking at potential $1,000 fine and potential jail time up to 6 months. But for the most part, you never have to do any jail time. And if the matter is resolved favorably, the fine's not that bad, and hopefully you won't even have a battery conviction. Now, if you're convicted of domestic violence, by statute, you have to spend at least 48 hours in jail. And if you're actually arrested, they will not let you out for 12 hours. And unlike DUIs, if you're arrested for domestic violence, if you're convicted, you will need to do the 48 hours in jail. Now, for DUIs, it's minimum 48 hours in jail, but you can do community service in lieu of the jail time. In addition, if you're convicted of domestic violence, you must do 26 domestic violence classes. That's first-time domestic violence. Second time, you have to do 52 weeks of domestic violence classes. So for a first time, it's 6 months, which is bad enough. And for a second time, it's an entire year. In addition, if you're convicted of domestic violence, under federal law, you are not allowed to possess a firearm. And I'm familiar with some cops that have been convicted of domestic violence, and they can't carry a firearm, so they end up losing their job. That's why it's really important not to be convicted of domestic violence. I mentioned the second time, that's minimum 10 days in jail, which you need to do, up to 6 months. And then if you're convicted of a third time domestic violence within 7 years, it's a felony, and the penalty is 1 to 5 years in Nevada State Prison, and it is non-probationable. So if convicted of a third time domestic violence, you will go to prison. And that's why it's so important to fight the first domestic violence to make sure we can avoid a domestic violence conviction. Now, there's many defenses. There's self-defense, protection of a third party, and there's legal defenses, or the way that the case is handled so it doesn't end up on as a domestic violence. If there aren't bad injuries, typically I can resolve the matter where it ends up as something less, such as misdemeanor battery, straight battery, or disorderly conduct, or best case basis, have the case dismissed at the end. And what usually happens is we'll do what's called a state adjudication. Client will plead guilty to something, many times domestic battery. If possible, I like them to plead something else, such as straight battery. And then they'll have these requirements, usually go to impulse control counseling, which is less than the domestic violence counseling. And depending on which class, you can do it online, and it only take up to 8 hours. Stay out of trouble, stay away from the victim, pay a fine, and then if you do all that, the case will be reduced to something, disorderly conduct, or as I said, best case dismissed, because if we get the case dismissed, then we'll be able to seal the record. So under Nevada law, if anyone asks you, have you ever been arrested or charged with a crime, you can truthfully say no. It is a legal fiction, but that's the law.
Okay, now, Mace, what if the victim doesn't want to press charges?
Well, that's interesting. And because of that, domestic violence is essentially in its own category. It is a misdemeanor, but along with DUI, it's the most serious misdemeanor. And because the state has a vested interest to make sure people are not convicted of domestic violence, then what needs to be done is we need to, excuse me, make sure that whatever happens, they do not get convicted of domestic violence. So if it ends up as battery or something like that, or anything else, it's much better. Now, the thing why it's different is that in any other crime, the victim, the accuser, needs to confront the client. It's the confrontation clause of the United States Constitution, which says you have a right to confront your accuser, you have a right to have them testify under oath, and you have the right to cross-examine them. However, under Nevada law, the state can proceed without the victim, even if the victim says, I don't want to prosecute. It's my spouse, we're back together, I don't want to do this. If the state chooses, they can say, too bad, we're going to proceed. And they can use what's called reliable hearsay. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. And in layman's terms, somebody said something, and we're going to tell you what they said in order to prove what they said is true. So that's why in 99% of the criminal cases, you can't do that, because what if that person's lying? You don't have the opportunity to cross-examine. But the state can proceed, and they still need some evidence. Sometimes the officer will say, oh, well, the victim told me A, B, C, D, that this person hit her and injured her. And that would not come in, let's say, on a straight battery case, but because it's domestic violence and it's considered reliable hearsay, it would. With that being said, if the victim does not want to prosecute, usually we're able to resolve the matter. So it's not a domestic violence.
All right. Well, how do immigration issues play into this?
Well, under immigration law, if you are not a citizen, you're convicted of either a crime of violence or a crime involving moral turpitude, which is theft, something like that, you are deportable. Now, if you're convicted of domestic violence, you're certainly deportable for the most part. However, federal law defines domestic violence differently. And there is sometimes where even if you're convicted of domestic violence, depending on the facts, you would not be deportable, i.e., if the client smacks someone in the head and it's his spouse, gets convicted, that's considered a crime of violence based under the immigration laws. However, sometimes people can be convicted, let's say, throw a computer, it bangs off the wall, and then it hits someone. Now, if those are the facts, that would not be considered a crime of violence according to immigration law. So what we're able to do sometimes, people will come to me after they're convicted, and sometimes I'm able to convince the DA, look, we just want to amend the facts. We're not saying He's not convicted of domestic violence. We don't want to change anything else. If he gets convicted again within 7 years, the penalties are progressive and they're much more severe. That's not our goal. Our goal is to keep my client in the country. And many times we're able to do that. Sometimes we're not.
And what if the defendant is out of town?
Well, many times tourists will come to Las Vegas, they'll have a few drinks, they'll get into it, and they'll end up hitting each other. Lots of times it happens in the hotel. There'll be an altercation. Security guards will come and they'll arrest one or both people. If they're out of town and they hire me, I can make the first appearance. They don't need to show up. Actually, any client, I can make the first appearance. But since it's a misdemeanor, as long as we're able to agree on a resolution, we can do it entirely through paperwork. We do something called a waiver of appearance and entry of plea. The client fills it out in front of a notary. We file it with the court. Now, many times because the clients are out of town, especially if the victim's out of town, I'm able to resolve the matter where it ends up being dismissed at the end. Then you can seal the record and everyone's happy. But it just depends on the situation. Obviously, if someone's bleeding from a head wound, that would be a felony domestic violence with substantial bodily harm. And there's also domestic violence by strangulation, which is a felony. And that carries much more severe penalties. And if it's a felony, the client needs to appear. You cannot resolve a felony if they're out of town, except very, very narrow situations. Usually if someone's in custody on a very serious crime, we're able to do that.
All right. Well, Mace, thank you so much for that wealth of information. And if you have been accused of domestic violence, the first consultation is always free, and you can reach Mace at 702-385-9777 or at www.macelaw.com. That's www.macelaw.com. Thanks, everyone.